SwayamPrabha. Digital India. Educated India.
Hello students, welcome to SwayamPrabha. I am Dr. Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. I and Dr. Saurabh Rana, my colleague from Faculty of Law, University of Delhi, are delivering this course on Procedural Criminal Law, Bharatiya Nagarik Suraksha Sanhita 2023. Today, I will be delivering the 15th lecture of this series. The title of today's lesson is Plea Bargaining. So students, let us understand how this concept of plea bargaining came around. So the basis is in the principle of nolo contendere. See, the principle of nolo contendere means I do not wish to contend. I neither accept the charges nor do I deny the charges, but I want to save myself the trouble of litigation, so that is why I accept the punishment. Okay? So you see, the person against whom the accusations have been levelled, he is neither denying the charges nor he is accepting them, but he is willing to just accept the punishment in order to get over with the litigation and the pain and the trouble and the trauma that is all associated with litigation process. So the modern concept of plea bargaining, it emerged in the 19th century, having its trace in American judiciary. In America, the accused can put forward one of the three pleas, that is guilty, not guilty and nolo contendere. Nolo contendere or no contest. It is not an admission of a guilt, but it is a willingness to accept a mere declaration of a guilt. See, not an admission of a guilt, mere declaration of guilt. Instead of going to trial, the person says, okay, I do not wish to contend and I accept. So, however, the court is not bound to accept such a plea of the accused. The court has a discretion. It may either accept the same, and if the court feels so, it can reject also such a plea, and the basis would be the facts, the circumstances of each and every case that are presented before the court. So what the court has to do, it has to ensure that the plea has to be put voluntarily by the accused person. There should be no duress or force or any kind of a compulsion exercised on the accused to accept the plea of guilty. So the court has to determine the voluntariness of the accused. It has to come from the side of the accused voluntarily, and the accused should make an informed and a conscious choice. These are equally important, that the accused should know what he is settling for. So this concept of plea bargaining, it gained a momentum due to overcrowding in prisons of USA. However, India did not feel the need for plea bargaining due to the presence of the jury system until the 1960s, when legal representation was permitted. So what are the kinds of plea bargaining? Okay, speaking generally, plea bargaining can be categorized broadly into three types. One is charge bargaining, the other one is sentence bargaining, and the third one is fact bargaining. So it could be either charge bargaining, sentence bargaining or fact bargaining, but each of these types would involve less sentence, there would be a reduction in the punishment, but these are different ways of achieving the same objective. The objective is just a reduction in the sentence that the accused is looking at. For that, he might opt for charge bargaining, sentence bargaining, or fact bargaining. The way may be different, the destination is the same. So, what is charge bargaining? So, charge bargaining is a very common form of plea bargaining. In this, usually the accused negotiates the charges with the prosecution. So, you see, there is a negotiation of specific charges or crimes that the defendant is about to face at trial. Usually, in return for a plea of guilty to a lesser charge, what the prosecutor does is dismiss the higher or other charge counts. For example, a defendant charged with burglary may be offered the opportunity to plead guilty to attempted burglary. It is therefore an exchange of concessions by both the sides. See, the prosecution can drop certain charges when there are a number of charges against the accused person, or they can just argue against the accused on basis of a lesser charge as compared to the original charge. And what the accused does, he agrees to plead guilty in case the prosecution drops the more serious charges. So, it is sort of a win-win situation for both, because the accused knows that he can now get away with a lesser punishment. The prosecution also knows at the same time that otherwise the litigation would take a long time. The entire burden is on the prosecution, and the burden that the prosecution has to discharge is a very huge burden. See, they have to prove the guilt of the accused beyond reasonable doubt, in case there is any kind of a doubt. And doubt can come in through two ways. One is where the prosecution fails to establish all the essential ingredients of a crime. And in criminal laws, usually we interpret the law strictly, in the sense that the burden is on the prosecution to prove each and every essential element or ingredient of the charge. So, in case the prosecution fails to establish each and every ingredient, then what happens? There is a doubt, and the doubt goes to the benefit of doubt, it goes to the accused person. On the other hand, suppose the prosecution succeeds in establishing the charges beyond reasonable doubt, but when the defense presents its side of the case, the defense also presents its own version or argues in such a manner that the court is compelled to ponder upon the possibility of the defense version also being true. So, now the court is again in two minds, that see, what the prosecution is saying appears to be true, but then what the defense is saying also appears to be true. So, there is a possibility of this contradiction being created, and when this confusion is created, there is a doubt, and whenever there is a doubt, whether it is on account of some shortcoming on part of the prosecution or whether it is on account of the defense arguments, but whenever there is a doubt, the benefit of doubt, it always goes to the accused person. So, what happens? This is a win-win kind of a situation for both. When we talk about charge bargaining, the prosecution drops certain charges, the accused accepts certain lesser severe charges, and the trial, it can be concluded in a very short time, which otherwise would have taken a very long time. So, that would be about charge bargaining. The next kind of bargain is sentence bargaining. So, this involves assurance of lighter or alternative sentences in return for defendants pleading guilty. So, you see, the sentence bargaining would involve an agreement to a plea of guilty for the stated charge rather than a reduced charge. In charge bargaining, we are bargaining for charges. In sentence charges, in sentence bargaining, we are pleading for a reduction in sentence while we retain the same charges. So, there is no reduction in the charges, the accused pleads guilty to the same charges, but in return what the prosecution does? The prosecution does not press the court for heavy sentences. It says that maybe there could be an alternative sentence which would be sufficient in the given case. So, what happens in sentence bargaining? There is an agreement to a plea of guilty for the stated charge rather than a reduced charge in return for a lighter sentence. It sources the prosecution the necessity, it spares the prosecution the necessity of going through trial and proving its case. It provides the defendant with an opportunity for a lighter sentence. So, it is the process which is introduced in India where the accused, with the consent of the prosecutor and complainant or victim, would bargain for a lesser sentence than what is actually prescribed for the offence. See, because in majority of the crimes in India, when we go through the text of our substantive criminal law, which is the Bharatiya Nyaya Sanhita 2023, when you will go through the scheme of the law, you will see that in majority of the offences, what has been prescribed is the maximum sentence. And then there is a discretion with the courts that if they deem fit, they can award a lesser sentence. It is only in very grave crimes that now the sentencing policy has changed in some cases, and now sometimes we prescribe the minimum sentence also, and in such cases there is a discretion with the courts that depending upon the gravity of the crime, they may award a higher sentence than the prescribed minimum. But ordinarily what is prescribed is the maximum sentence, and then the courts, they have so many things to consider, so many things to be kept in mind while they arrive at the appropriate sentence. See, the law has prescribed a sentence of 5 years, that is the maximum sentence. Now, depending upon the facts and circumstances, the courts may decide to sentence the accused for whether 4 years, 3 years, 2 years, 1 year, maybe only 6 months. So, there is a lot of discretion with the courts. They are supposed to state the reasons why they chose to provide a lesser sentence. So, what happens in sentence bargaining? When there is already an agreement between the prosecution and the defense, the accused pleads to the charges, and in return the prosecution does not press for higher sentence for the accused person. Then the third kind of plea bargaining is fact bargaining. Now, this is the least used negotiation, and what it involves is an admission to certain facts. Thereby, the prosecutor need not establish those facts beyond reasonable doubt. So, there is a benefit for the prosecution in the sense that the necessity of proving those charges for the prosecution has been eliminated, but what is the bargain in return? That see, the prosecution is not going to introduce certain other facts into evidence. So, suppose the prosecution has some 10 points that it intends to present before the court. So, there is a bargain struck between the parties that okay, you will present these 5 facts, I will admit to them, the other 5 facts you will not present before the courts. So, you have dropped certain facts from being presented before the courts, and the other facts that would be presented on the basis of which I could get a lesser punishments or some lesser charges could be framed against me. So, again it is a win-win situation for both. The prosecution has been saved the burden of proving all those other facts also, and the defense also gets away with a lesser sentence. So, you see, the expression defendant is used in India in the civil dispute against whom civil action is taken, whereas in USA this expression is used in criminal trial also, and thus the defendant is also an accused. Now, why do I need to talk about this is because when we talk about the concept of plea bargaining, it is something that we have borrowed extensively from the American model. See, there are a couple of cases. There was Fox versus Shedid, and in State Exrell Clark versus Adams, the plea of nolo contendere Sometimes also plea of nolvut or nolle contendere means in its literal sense, I do not wish to contend, and it does not origin in early English common law. This doctrine is also expressed as an implied confession. It is a quasi confession of guilt, a plea of guilty, substantially though not technically a conditional plea of guilty, a substitute for plea of guilty, a formal declaration that the accused will not contend, a query directed to the court to decide on plea guilt, a promise between the state and the accused, and a government or a state agreement on part of the accused that charge of the accused must be considered as true for the purpose of a particular case only. What was our judicial view on plea bargaining before it was introduced in the criminal justice system in the year 2005? See, we all know Mallimat committee had recommended introduction of plea bargaining, but before that, when it was formally introduced in India in the year 2005, before this Amendment Act, we were not very keen on plea bargaining. The Indian judicial system did not recognize the concept of plea bargaining and thus opposed it. Pre-amendment, the apex court repeatedly declared that the concept was against public policy. Because see, we go by the criminal law principles, let 99 guilty men go free, one innocent should not be punished. So what that implies is, suppose a person is scared of litigations, and because the person does not want to face litigation, maybe he is a poor person, maybe he cannot afford the costs of litigation or the time that would be wasted in it, the energies and the involvement of all the family members, they would all be disturbed in case the accused is put to litigation. So suppose there is a poor person possessed of less means. Now this person, there is some allegation levelled against him, those allegations might be false, but that person, he agrees to plead guilty. So that would not be fair, because we believe that in case anybody is innocent, that person should not be punished, and we believe in this to the extent that even if so many guilty men were to go free, but what we have to ensure is not even a single innocent should be punished, and that is why we did not accept or acknowledge the concept of plea bargaining. See, there was a judgment in Muralidhar Meghraj Loya versus State of Maharashtra. This is a 1976 judgment in which the Supreme Court held, it is idle to speculate on the virtue of negotiated settlements of criminal cases as obtains in the US, but in our jurisdiction, especially in the area of dangerous economic crimes and food offences, this practice intrudes on society's interests by opposing society's decision expressed through predetermined legislative fixation of minimum sentence and by subtly subverting the mandate of the law. See, this is a 1976 judgment. By that time, we were just talking about what is the concept of plea bargaining, but we were not exactly clear about how to implement it in India. So, the concerns were genuine. At that time, it was not yet decided that plea bargaining would not be applied in case of socio-economic offences. So, the concern of the lordships in this case was very much genuine. See, what would happen that two parties can enter into a pre-negotiated settlement, and what in case of heinous crimes, dangerous economic crimes, food offences, like we have the Food and Safety Standards Act, we have the Psychotropic and Narcotic Substances Act, then we have Infant Foods Act. So, there are so many socio-economic legislations for the welfare of the society, but if we were to allow plea bargaining, this concept to be brought in all cases, then what would happen? The accused could go scot-free. The accused would know that, okay, I can settle for this much. So, that was the reason why the judges were opposed to this kind of a concept. Then there was another judgment, State of Uttar Pradesh versus Chandrika, 2000. The Supreme Court held, it is settled law that on the basis of plea bargaining, court cannot dispose of the criminal cases. Mere acceptance or admission of the guilt should not be a ground for reduction of sentence, nor can the accused bargain with the court that he is pleading guilty, so his sentence should be reduced. So, you see, by that time, because we were not open to the concept of plea bargaining, so there were a lot of misapprehensions, misconceptions surrounding this concept, and it was like maybe the accused will come and the accused will try to strike a bargain. See, the term bargain in itself appears very materialistic, and when we are talking about the high ideals of justice, so introducing concepts such as bargain was something which was not acceptable to us, especially since the detailing had not been worked out by that time. Then there is a very important judgment, State of Gujarat versus Natwar Harchandji Thakur. This is a 2005 judgment. Now, what had happened in this case? The courts, they had delivered certain very important observations. See, whether plea of guilty is plea bargaining or not will be a matter of fact to be examined in each case from the factual matrix of the case and totality of the context and entire profile. It cannot be contended that every plea of guilty is always plea bargaining in case of each case and each accused. It cannot be also assumed without supporting facts and attending circumstances. It is a matter of proof and of an objective and independent evaluation of facts. It is found to the satisfaction of the court, then it can be allowed and sustained, being not legal and permissible in those cases based on facts and proof thereof. Thus, it is a matter of proof and evaluation of evidence in each case. Then in again para 89, the very object of law is to provide easy, cheap and expeditious justice by resolution of disputes, including the trial of criminal cases, and considering the present realistic profile of the pendency and delay in disposal in the administration of law and justice, fundamental reforms are inevitable. In fact, they are desirable. So, there should not be anything static. As such, change is the only constant thing in the world. If the individuals, society, or for that purpose, nation feels allergic to the change for the reforms and remaining oblivious to the realism and prevalent situations, the very existence may be in jeopardy. It is therefore rightly said that all must have an open mind, as mind is like a parachute. It starts working only when it is open. Although hitherto, as a part of colonial legacy, plea bargaining has not been recognized so far in our system and criminal jurisprudence. However, keeping in mind the huge arrears and long time spent in trials and resultant hardships to parties, and particularly the accused and the victims of the crimes, the benefit of plea bargaining as an alternative method to deal with the dispute or question of offence requires serious consideration, which would not be admissible and available to the habitual offenders. We should remember a saying that every saint has a past and every sinner has a future, and also that law and justice should not be distant neighbors. So, that is why students, what was emphasized in this judgment was that we need to approach and embrace the new concept of plea bargaining. We need to try and understand what are the benefits of adopting this kind of an approach. We need to decolonize our mindset. See, plea bargaining was not there in the colonial system, and our criminal law was totally accepted from them. So, as it is, if we were to close our minds to the fact that anything which is not a colonial legacy is not good, or maybe that is not just or should not be accepted. So, now is the time to shed that, and we need to understand, as it has been quoted in this judgment, change is the only constant. So, change, it is very important for any society to grow. The society changes, and accordingly, to cater to the changing needs of society, the law also needs to grow. The law needs to evolve in order to meet the rising challenges to the society through the new kinds of crimes that are evolving over the years. So, the law necessarily needs to keep updated with those, otherwise there would be no law and order in the society. So, we need to embrace and accept new principles, because that is the need of the hour. Then, however, the Indian judicial system saw a shift in the perspective, recognizing the concept of plea bargaining after 154th Law Commission report on the Code of Criminal Procedure 1973, which recommended the introduction of plea bargaining. The committee took views from judges, lawyers, bar associations, etc. The recognition of plea bargaining has made a deep impact over the years, and now it has become an essential part of criminal justice system or criminal jurisprudence in India. Now, what is the Indian position? The Malimat Committee, or popularly known as the Committee on Reforms of Criminal Justice System 2003, recommended that a system of plea bargaining be introduced in the Indian criminal system to facilitate the earlier disposal of criminal cases and to reduce the burden of the courts. Accordingly, the draft Criminal Law Amendment Bill 2003 was introduced in the Parliament. Eventually, Chapter 21A was inserted in the Code of Criminal Procedure 1973 by the Criminal Law Amendment Act 2005. It was enforceable from 5th July 2006. Now, this provides for pre-trial negotiations between the defense and the prosecution. See, look at the language, it says pre-trial negotiations. That is, it is the stage after the formulation of the charges, but prior to the commencement of the trial. So, these are pre-trial negotiations between the defense and the prosecution, during which an accused might plead guilty in exchange for certain concessions by the prosecution. The statement of objects and reasons inter alia, that is among others, mentions that the disposal of criminal trials in the courts takes considerable time, and that in many cases trials do not commence for as long as 3 to 5 years after the accused was remitted to judicial custody, and that is the reason why we have a huge number of under trials languishing in our prisons. The consensus part is restricted to the sentencing part alone, as the conviction stays on the acceptance of guilt by the accused. Additionally, it reduces the burden of the court, the state, the victim and the accused facing agonizing litigation while serving the cause of justice. So, you see, when we are talking about plea bargaining, it is supposed to be beneficial to the state, it is supposed to be beneficial to the accused, to the prosecution, to the society. Overall, this is supposed to be a beneficial proposition. However, hardly 1% of the cases are taken up for plea bargaining, presumably for the reason that the accused are either illiterate or they are reluctant to use this better option, which would bring the case to a close at an earlier date than expected. See, what is the reason? The accused persons, they are illiterate, they are not aware, they do not know what plea bargaining is about. Legal aid lawyers, even if assigned, sometimes they might not be able to communicate this in a very proper manner, and at other times the accused might not be willing to trust them completely, due to which what happens, because they are not aware of the entire scheme of plea bargaining, what happens, they are reluctant to accept that, due to which what happens, they keep on languishing in prisons. Now, let us talk about the statutory provisions relating to plea bargaining in our law. In Bharatiya Nagarik Suraksha Sanhita, Chapter 23 deals with plea bargaining, that is covered under sections 289 to section 300. So, under section 289 of Bharatiya Nagarik Suraksha Sanhita, let us first of all talk about the application of this chapter. Plea bargaining is there in a separate chapter. Now, what is the application of this? The chapter shall apply in respect of an accused against whom the report has been forwarded by the officer in charge of the police station under section 193 alleging therein that an offence appears to have been committed by him other than an offence for which the punishment of death or imprisonment for life or of imprisonment for a term exceeding 7 years has been provided under the law for the time being in force, or a magistrate has taken cognizance of an offence on complaint other than an offence for which the punishment of death or imprisonment for life or imprisonment for a term exceeding 7 years has been provided under the law for the time being in force, and after examining complainant and witnesses under section 223 issued the process under section 227, but does not apply where such offence affects the socio-economic condition of the country or has been committed against a woman or child. So, what is the application of this chapter? In which categories of cases can plea bargaining be invoked? So, first is, it can be invoked only where the accused has been where the person has been accused of an offence which is not punishable with either death penalty or which does not entail a punishment of life imprisonment or which does not entail a punishment of imprisonment exceeding 7 years. So, only in those crimes where the punishment that has been prescribed under the statute is less than 7 years can the concept of plea bargaining be applied. Further, there is another clarification, and that is, even if the punishment that is prescribed is less than 7 years, but if the crime is of a socio-economic nature, see, if the crime is such that it is affecting the socio-economic condition of the country, or where the crime has been committed against a woman or the crime has been committed against a child, then in such cases plea bargaining will not be applied. So, plea bargaining is not applicable in cases where the punishment is death penalty, life imprisonment, imprisonment for more than 7 years, or where the crime is against the socio-economic fabric of the country, the crime is against a woman or a child. In all other cases, we can invoke plea bargaining, but in these categories, plea bargaining is a strict no-go zone. For the purposes of subsection 1, the central government shall by notification determine the offences under the law for the time being in force, which shall be the offences affecting the socio-economic condition of the country. So, now what is a socio-economic offence? What all offences fall under the category of socio-economic offences? Now, that is again something which has not been left to the discretion of the judiciary or the prosecutor or the defence to plead either ways. There is a complete list of these socio-economic offences that has to be published and that has to be notified. So, whenever in doubt, we can straight away refer to that list. If the offence is listed in that due list, if that act under which the accused has been charged, that particular statute is listed in that list, it would be deemed to be a socio-economic offence, otherwise it would not be one. So, now how do you apply for plea bargaining? So, section 290 prescribes the procedure for application of plea bargaining. a person accused of an offence may file an application for plea bargaining within a period of 30 days from the date of framing of charge in the court in which such offence is pending for trial. So, there is a prescribed timeline that once the charges have been framed. So, if you need to opt for plea bargaining, you have to opt for that within a period of 30 days from the date of framing of charge. See, now especially after we have changed our CRPC to Bharatiya Nagarik Suraksha Sanhita, the objective is to protect our citizens, the objective is to streamline the criminal justice machinery, the objective is to ensure that there is an end to litigation. How can that be achieved? By fixing the timelines. Okay? So, we have to minimize the pressure on the courts. How can that be done? They have to wind up the cases so that the past backlog does not keep on accumulating and people have confidence in the justice system. So, what it says is within 30 days from the date of framing of charge, the person may file a plea for an application for plea bargaining. The application under subsection 1 shall contain a brief description of the case relating to which the application is filed, including the offence to which the case relates, and this shall be accompanied by an affidavit sworn by the accused stating therein that he has voluntarily preferred. So, you see, voluntariness is not to be compromised. In order to ensure the voluntariness on the part of the accused person, there has to be a sworn affidavit deposited in the courts. It is not that he can just write or admit it, it has to be a sworn affidavit, and only then the court is going to accept it. So, the affidavit has to be given by the accused therein that he has voluntarily preferred after understanding the nature and extent of punishment provided under the law for the offence. So, it has to be a duly informed permission that the accused gives. Provided under the law for the offence, the plea bargaining in his case, and that he has not previously convicted by a court in which he had been charged with the same offence. See, for repeat offenders, again the law is not going to make any concession. So, the accused has to make a plea that I have not previously been charged for an offence of the same character. I know what is the sentence that my accepting of this plea bargaining will entail, and that I am voluntarily going in for it. So, it is only after all these things they have been sworn in the affidavit that the court may permit. After receiving the application under subsection 1, the court shall issue notice to the public prosecutor or the complainant of the case and to the accused to appear on the date fixed for the case. When the public prosecutor or the complainant of the case and the accused appear on the date fixed under subsection 3, the court shall examine the accused in camera, where the other party in the case shall not be present to satisfy itself that the accused has filed the application voluntarily. See what happens, there is a possibility that the accused might have been pressurized by the police or by the prosecution into admission of his guilt. There is a possibility the accused might be an innocent person, he was not aware, he was falsely implicated because the investigation had to be concluded, there might be a mistake on part of the police officials or whatever the reasons may be, but where the accused has been compelled into accepting this plea bargaining. So, what is required is the magistrate has to ensure himself of the voluntariness of the process. For that, he has to talk to the accused person in the absence of the prosecution. Then, where the accused is satisfied that the application has been filed by the accused voluntarily, it shall provide time not exceeding 60 days to the public prosecutor or the complainant of the case and the accused to work out a mutually satisfactory disposition of the case, which may include giving to the victim by the accused the compensation and other expenses during the case, and thereafter fix the date for further hearing of the case. So, a mutually satisfactory agreement has to be entered into by the parties within a period of 60 days if the court permits the application of plea bargaining. But if the court finds that the application has been filed involuntarily by the accused, or he has previously been convicted by a court in a case in which he had been charged with the same offence, it shall proceed further in accordance with the provisions of this Sanhita from the stage such application has been filed under subsection 1. Then plea bargaining shall not be accepted and the trial will proceed as if the trial would have otherwise proceeded. See, there is this judgment Mallikarjun Kodagali versus State of Karnataka and others, in which the court held Parliament also has been proactive in recognizing the rights of victims of an offence. One such recognition is through the provisions of chapter 21A CRPC, which deals with plea bargaining. See, this is the old chapter, now this is chapter 23 of BNSS. So, Parliament has recognized the rights of a victim to participate in a mutually satisfactory disposition of the case. This is a great help, or this is a great leap forward in the recognition of right of victim to participate in the proceedings of a non-compoundable case. See, ordinarily in our criminal justice system, victims, they are not given any kind of a participation. There is no presence of the victim except where the prosecution desires. Sometimes the victims, they are brought in as witnesses. Otherwise, ordinarily the victims, they stay on the fringes of the system and the entire case revolves between the prosecutor and the accused. And punishing the accused, it does not necessarily translate into justice for the victim. So, when we talk about plea bargaining, this is in a way we are allowing the victim some sort of a voice, so that the victim and the accused, if they can work out on a mutually satisfactory disposition. Suppose there was some damage, some harm that was suffered by the victim, and if the accused is willing to make good the loss, so maybe the victim might be willing to drop certain charges and accept a lesser sentence, not press for a higher sentence for the accused person. So, that ways it works for both the parties and it brings the victim also in the system. So, now what are the guidelines for a mutually satisfactory disposition? Section 291 of the BNSS lays down guidelines regarding this. In working out a mutually satisfactory disposition under clause A of subsection 4 of section 290, the court shall follow the following procedure, namely, in a case instituted on a police report, the court shall issue notice to the public prosecutor, the police officer who has investigated the case, the accused and the victim of the case to participate in the meeting to work out a satisfactory disposition of the case. So, what happens? Notice is to be given to all the stakeholders. It could be the prosecutor, the police officer who was involved in the investigation, who was the accused person, who was the victim. So, they all can work out a mutually satisfactory disposition of the case, provided that throughout such process of working out a satisfactory disposition of the case, it shall be the duty of the court to ensure that the entire process is completed voluntarily by the parties participating in the meeting. See, here they are not talking only about voluntariness of the accused person. See, sometimes the victim might not be willing to settle for anything but the extreme penalty for the accused person. So, the victim is not willing to let go of the situation. So, the victim is not participating in it voluntarily, and the victim also cannot be pressurized into entering into an agreement where the victim does not want to enter into such a situation. So, here what is required is that the court has to ensure that there has to be total voluntary participation of the parties, whether it is the accused, whether it is the victim. It should not be that powerful accused persons can take poor victims for a ride. This should never happen and this should never be allowed, and that is why this entire kind of settlement, it is monitored by the state. It is the court which decides whether permission has to be given or permission has not to be given. See, even where both the parties, they have given an affidavit, but the court feels that the parties have not done it voluntarily, the court can refuse to accept this application for plea bargaining. Then provided further that the accused, if he so desires, may participate in such meeting with his advocate, if any, engaged in the case. So, you see, the accused has been allowed some sort of a legal representation also in this case. Then, in a case instituted otherwise than on police report, the court shall issue notice to the accused and the victim of the case to participate in a meeting to work out a satisfactory disposition of the case, provided that it shall be the duty of the court to ensure throughout such process of working out a satisfactory disposition of the case, that it is completed voluntarily by the parties participating in the meeting, provided further that if the victim of the case or the accused so desires, he may participate in such meeting with his advocate engaged in the case. So, what is the difference between A and B? The only difference is that in A, legal representation is permitted only to the accused, but in cases that are instituted otherwise than on police report, legal representation is permitted to the victim as well as the accused. Then 292 talks about the report of mutually satisfactory disposition to be submitted before court. It says, where in a meeting under section 291, that is whether it is a case instituted on a police report or otherwise, where all the parties have been asked to meet and arrive at a mutually satisfactory disposition. So, where such a meeting is held under 291, a satisfactory disposition of the case has been worked out during such a meeting. The court shall prepare a report of such disposition. So, you see, the parties just have to arrive at a mutually satisfactory disposition. The report has to be drawn by the court. So, the court shall prepare a report of such disposition, which shall be signed by the presiding officer of the court and all other persons who participated in the meeting, and if no such disposition has been worked out, the court shall record such observation and proceed further in accordance with the provisions of the Sanhita from the stage the application under subsection 1 of section 290 had been filed in such case. So, if that agreement is not arrived at between the parties, if the meeting it fails, then in such cases the court will proceed as if ordinarily the trial would have proceeded from that stage, but if they have agreed to it, then the court shall prepare a report of the such disposition, that is, what are the mutual terms that have been agreed upon by both the parties. Then section 293 deals with disposal of case. So, where a satisfactory disposition of the case has been worked out under section 292, the court shall dispose of the case in the following manner, namely, A, the court shall award the compensation to the victim in accordance with the disposition under 292, and hear the parties on the quantum of the punishment, releasing of the accused on probation of good conduct or after admonition under section 401, or for dealing with the accused under the provisions of the Probation of Offenders Act 1958 or any other law for the time being in force, and follow the procedure specified in the succeeding clauses for imposing the punishment on the accused. So, the court shall ensure that whatever the agreement was arrived at between the parties, whatever was the terms of the mutually satisfactory disposition, that is whether some charges were dropped, whether the accused is to be released on probation only after admonition, or whether the parties have agreed to some compensation to the victim. So, the court has to award all that to both the parties. Then, after hearing the parties under clause A, if the court is of the view that section 401 or the provisions of the Probation of Offenders Act or any other law for the time being in force are attracted in the case of the accused, it may release the accused on probation or provide the benefit of any such law. After hearing the parties under clause B, if the court finds that minimum punishment has been provided under the law for the offence committed by the accused, it may sentence the accused to half of the minimum punishment. See what happens. Where the statute has prescribed a minimum punishment, then ordinarily that statutory prescribed minimum is to be awarded in case the accused is found guilty. But in cases of plea bargaining, even in those cases a concession has been made. So, now even if the statute has prescribed a minimum sentence for that offence, if the accused pleads guilty, then even in those cases what would happen? It may sentence the accused to half of such minimum punishment. And where the accused is a first time offender and has not been convicted of any offence in the past, it may sentence the accused to 1/4 of such minimum punishment. So, you see now there is an ample discretion with the courts even in cases of those crimes for which there is a statutory prescribed minimum sentence. So, in cases of plea bargaining we can reduce to half of the prescribed minimum, and where further the accused is a first time offender. So, we have to take a very fair view of the things, give him a second chance and see, because that is what the objective of the law is. Bharatiya Nyay Sanhita, Bharatiya Nagarik Suraksha Sanhita. So, as per the new laws, now we have to take a lenient view in case the accused has admitted his guilt, is willing to change his ways, the victim has also accepted the terms of settlement. It is a mutually satisfactory disposition, and if the court feels that this is a fit case, the accused is a one-time offender, then in such cases a concession can be made and the punishment that would be awarded would be 1/4 of the prescribed minimum. In case after hearing the parties under clause B, the court finds that the offence committed by the accused is not covered under clause B or clause C, then it may sentence the accused to 1/4 of the punishment provided or extendable for such offence, and where the accused is a first time offender and has not been convicted of any offence in the past, it may sentence the accused to 1/6 of the punishment provided or extendable for such offence. So, even a more lenient view can be taken and it could be 1/6 of the prescribed minimum in such cases. Now, section 294, judgment of the court. The law says, the court shall deliver its judgment in terms of section 293 in the open court, and the same shall be signed by the presiding officer of the court. So, whenever a decision has been taken on the basis of that mutually satisfactory disposition between the parties to the case, then the decision that is given by the court, it is in the form of a judgment in terms of 293, and it is also to be pronounced in open court. What do we mean by open court? That anyone is free to go and attend the proceedings, and when such a judgment is delivered, it shall be also signed by the presiding officer of the court. Now this kind of a decision has a finality to it because it has been pronounced by the court. Although the judgment embodies what the parties wanted, but still there is a finality of this judgment that is provided under section 295, and this judgment is final and there is no remedy against the same except SLP under article 136 and writ petitions under articles 226 and 227 of the Constitution. Otherwise, under no other court can it be challenged. and the court has all the powers as that of a bail, trial of offences and other matters as they have in other cases. Similar powers they have while exercising powers under plea bargaining provisions. Then the period of detention that the accused has already undergone by in this case, that has to be set off against the sentence of imprisonment that is eventually awarded to the accused by the court. And statements that the accused gives in as a part of plea bargaining process, they are not to be used against him in any other proceedings. They are to be used only for the purposes of plea bargaining. And further, section 300 clarifies, nothing in this chapter shall apply to any juvenile or child as defined in section 2 of the Juvenile Justice Act. See, Justice Call had noted in this recent judgment, the problem is also between sentence bargaining and offence bargaining. We have only incorporated one, that is sentence bargaining, that limits the aspect of plea bargaining. Countries like USA that have successfully implemented plea bargaining have encompassed both the aspects of sentence and charge bargaining. See, the clogging of courts by criminal matters on all hues of various vintages is an important aspect. We consider it appropriate to put it to the Government of India for that matter for discussion with the states as to whether in offences where period of custody before High Court has exceeded a certain percentage of the maximum sentence, say 1/3 or 40%, and the person is willing to submit a bond of good behaviour, those cases can be closed in one go after scrutiny so that the trial courts are unburdened of these cases and are able to concentrate on more heinous cases. We say so in the context that though plea bargaining has been introduced in CRPC, somehow it has not worked because the social stigma of conviction may be preventing the accused from accepting the bail and accepting a plea bargaining position. So, before we conclude, a quick recap. See, what are the advantages of plea bargaining? We have an alternative mechanism. The pending cases, they might be reduced. Overcrowding of prisons can be taken care of, and it can help provide a closure to the victims. On the flip side, only the accused has a power to plea bargaining. The victim cannot initiate the same, and by pleading guilty to a lesser charge, the accused is giving up their right to a fair trial, and there is also a possibility of corrupt practices creeping in. Although when we have provided for judicial monitoring, we have tried in a way to minimize the chances of this so happening. So students, this would be all about the concept of plea bargaining. I hope you enjoyed this lecture. Thank you.